Order, order. Good afternoon and welcome to this public evidence session of the Procedure Committee. This afternoon's session is the next one in our inquiry into the sub judice resolution in the House of Commons. We're now coming towards the end of our inquiry and we're taking the opportunity of asking the government for its perspective on the evidence that we have heard to date. And to that end, I'm delighted to be joined this afternoon by the Attorney General for England and Wales, Lord Hermer, Casey. Good afternoon and thank you for joining us. Before we begin, could I ask you to introduce yourself formally for the record?
Of course, I'm Richard Hermer, I'm the Attorney General.
You're very welcome. And as is traditional, the first question comes from myself, and it is often said that the twin aims of the sub judice resolution are about maintaining comity between Parliament and the courts and avoiding prejudicing legal proceedings. In your view, do they both matter equally, or is one aim more important than the other?
That's a really good starting question. I think they are both of fundamental importance to our constitution, our constitutional framework, and it's about where the balance lies. So I think the essential starting point is the constitutional principle that Parliament must be free to discuss any matters that Parliament thinks fit. That's a kind of a bedrock principle in a democracy under our constitutional framework. It's also one that has been long fought for. I'm not sure the extent to which the committee's had some evidence on the history of it. I mean, it kind of starts out with parliamentarians trying to create as much space and freedom as they could in Tudor times. Then by the time it doesn't go so well, it gets even worse under Charles I. I mean, some of you will know in 1629, 2 parliamentarians were arrested for sedition for comments they made in Parliament. That increases the friction. It gets even greater in, I think it's 1649, the King comes to Parliament to try and have 5 parliamentarians named, is effectively ejected to the cry of privilege. We then come to a point in which the importance of parliamentary privilege is really enshrined when we get to the Bill of Rights of 1689. And it's that fundamental principle necessary for democracy that parliamentarians are free to say what it is they want to say. Now, there's a balance to that with another really important constitutional principle, that we have a separation of powers in this country and that the adjudication of disputes is allocated to independent courts that are independent of Parliament and independent of the executive. And allied to that is another really important constitutional principle, that we're all entitled to fair trials. And so what we see with parliamentary privilege and what we see with the development of the sub judice rule is the balance being struck. Parliament decides, it's a self-denying ordinance from Parliament, the sub judice rule. Parliament decides that to respect the balance between its rights and freedoms and the obligations to keep in place an independent court system and for trials not to be prejudiced, Parliament has decided to introduce and to comply with the sub judice rule. So I'm not sure necessarily that it helps to think about what's more important, but the starting point is parliamentary sovereignty and the importance of comity between the different branches of our constitutional setup.
Thank you very much. Our second question is coming from Kenneth Stevenson.
Thank you, Chair, and thank you, Lord Hermer, for being here. Given your experiences in the legal profession and now as a parliamentarian, do you think there is an equal degree of understanding of and respect for principle of comity within Parliament and the judiciary?
I'm going to say with some obvious degree of humility about the parliamentary perspective. I only came into the House of Lords in July 24. There'll be others who have far greater knowledge of how it's perceived in Parliament, how it operates in Parliament, how the extent to which it's understood by our colleagues in both houses. So I think I would pass on that. What I can say from my experience since July 24, I've seen nothing my own experience to question the operation of it. I've seen on the other side of the fence the enormous deference that is given by courts to parliamentary privilege. I mean, I did lots of cases in which Article 9 became an issue if one party or another wanted to rely upon proceedings in Parliament, and the way that the Article 9 rights of Parliament are upheld by the courts. So I've seen that from that side, but others are going to be much better placed than I am to comment about the extent to which it's ingrained in the fabric of life in this building.
Thank you.
Ambos.
Lord Hermer, my question is about the length of time that cases take. So obviously civil and criminal cases can take a number of years, and obviously the sub judice rule may still be in place for a number of years while those cases are going on. So my question to you is really just about whether the sub judice rule is a disproportionate restriction on the freedom of speech of parliamentarians, given that some cases may take such a long time.
I don't think it as a matter of principle, is an unjustified restriction. I mean, again, it's a restriction that Parliament has placed upon itself, and it's done so for the reasons that I've outlined. Whether there are cases, either because of the length of time that it will take for that case to get to court, or for a variety of other reasons, in which it may be appropriate for the Speaker to consider a waiver, is another matter. And that I could see as obviously a matter for the Speaker, but that could be, in certain circumstances, a factor to be taken into account. There'll always be upsides and downsides, risks and benefits when considering a waiver, but I don't see why, as a matter of principle, length of time couldn't be a consideration.
Lee Dillon.
Lovely. Yeah. Thank you, Lord Hermer. Do you think that the two Houses of Parliament should remain aligned in terms of operation of the resolution, or should the elected House have more scope to discuss urgent and emergent issues?
I mean, I can see the argument. I can see an argument for why there would be a difference. I mean, I think where I would land on that is that ultimately there is a benefit in having a single standard, because if you have a single standard, everybody knows where they are. But again, if you go back to the basic principles for why the sub judice rule exists, which is to respect the role that the courts have to play to avoid prejudice to trials, and I think ultimately the rationale for keeping that standard uniform is met.
Thank you.
Thank you. Hi, Lord Hermer. The sub judice rule can at times feel restrictive for members, often because there's a perception that they're being prevented from discussing matters in Parliament that are being discussed in the outside world and within the media. Do you think this is a fair perception?
Well, I think I can well understand the frustration of parliamentarians if constituents are either online or coming in and talking about a case and you can't raise that within the chamber or within a committee. And of course there is a frustration there. I think I come back to the question of the underlying principles. And it's always important in a modern democracy where you've inherited principles over decades and indeed centuries to kick the tires and ask ourselves, are they still fit for purpose in a modern age? And one of the things that one can test that by is this age of social media. For my own mind, I think those principles are so important that notwithstanding the frustration, I think the balance is still the right balance that has been struck. Again, whether or not in particular cases the level of information that is out there in the public domain, the level of concern that there may be around those issues would justify in an individual case a waiver is another matter.
You kind of touched on my follow-up question, which was around social media. Do you think there's any changes that should be made to consider social media within the sub judice rules?
Look, I think it's certainly a legitimate discussion to have. I don't know that ultimately, if what you want to do is ensure that parliamentary proceedings don't encroach upon the kind of constitutional lane that we've accorded to the courts, and if we want to ensure that we are protecting trials, that it is necessarily going to shift the dial across the board. Whether it does in individual case is another matter. But I think that's why I'm delighted this committee is looking at this issue so carefully. I mean, I think it's a legitimate discussion. There's a difference, of course, between members of the public on social media talking about a case, which can have a very damaging impact. I mean, I know you've been considering the Southport case. There's a difference between that and members of Parliament within Parliament talking about, not just because of the kind of constitutional element that might be said you're in someone else's lane, but actually because you have such a status, and because it has a status when you're saying it in Parliament on legal proceedings, there's a potentially there, again, depending on the case, potentially greater prejudice that would be caused to a fair trial.
Thank you. Mary.
Thank you. Thanks. Lord Hermer, do you think that comments made by MPs in parliamentary proceedings carry more weight than commentary in the media or on social media?
I think they certainly can do, yes. I mean, I think because, rightly, people look to parliamentarians and give weight to what parliamentarians say, particularly when they say it in Parliament. So I think that carries weight. I think probably if you're looking at it from a judge's perspective, trying to manage a fair trial, let's say it's a criminal trial, you're going to be very concerned if it comes from a parliamentarian, or certainly have greater concerns about the impact on prejudice if it comes from a parliamentarian than if it's just an individual tweeting.
Thank you.
So just to follow up on that, do you think it matters whether that was said in an adjournment debate or a PMQ, for example? Or is it the fact that you're saying it on the floor of the House that's the overriding?
I think the fact you're a parliamentarian saying it in Parliament, and of course there's a trade-off. I mean, if you're tweeting, you are liable to be prosecuted for contempt and go to prison for up to 2 years. If you're a parliamentarian, but you're protected by Article 9 of the Bill of Rights. So, I mean, to put it in language that was kind of very popular a couple of decades ago, together with rights come some responsibilities. And I think there's a balance there.
James.
Thank you. And this kind of follows on from we were asking about the role of members, because it's something MPs do consider about, when we're asking a question when there's a live legal case. So, could you tell us in what circumstances you think comments in Parliament could prejudice a trial and potentially lead to it being abandoned? And do you think that risk is higher with a jury trial than it would be with other types of cases?
Yeah, I think it's undoubtedly higher with a jury trial. Because if you're a criminal judge, you're charged with ensuring that defendant gets a fair trial. There haven't been many circumstances in which a trial has been abandoned because of comments made pre-trial. I can think of, off the top of my head, there's the Levy-Belfield case, which wasn't a parliamentarian comment, it was newspaper reporting, but resulted in, a serious charge having to be dropped. So it's a real concern. If you've got a judge alone, either because it's a sentence, there's been a conviction and you're moving to sentence in a criminal trial, or you're before the Court of Appeal, where there's no question about witnesses being intimidated, about juries having their mind distracted to things that are irrelevant and prejudicial, then the kind of risk of fair trial considerations are lessened. That's not to say they don't exist, but they're lessened. There are other factors beyond the fair trial that play, and beyond the mere kind of constitutional lane for courts. It's also about, we don't want to get into a position in which comments from parliamentarians are perceived by the public to be having an improper influence on courts, irrespective of whether it's a jury or not. But generally speaking, the risk of a fair trial are far greater in a criminal proceedings. Now, with a jury, you can still have them in other proceedings, not least civil proceedings. So you can still have, in civil proceedings, you could still see an improper attempt to influence witnesses or to intimidate witnesses in civil proceedings. We have had instances in which parliamentary privilege has been used to breach anonymity in a court order, for example. We've had a few instances of those over the decades. So insofar as your question is saying, can we just limit this rule to jury trials, I think the answer to that is no. Insofar as the question is there a greater risk of prejudice to a fair trial in a jury trial as opposed to others, then as a matter of generality, I think the answer is yes.
Thank you.
Lee Pitcher.
Thank you. In your role as Attorney General, Lord Hermer, what consultation do you have with government departments about issues which may arise in Parliament and whether they may or may not be sub judice?
Well, what would happen is if there were concerns amongst departments or indeed any of the kind of arm's length bodies that I superintend, not least, most relevantly here, the Crown Prosecution Service and the Serious Fraud Office, then they would come to me to raise those concerns. I think without breaching the Law Officers Convention, which means I can't talk about individual cases, I think I'm in the happy position that Baroness Scotland and Jeremy Wright and others were in when they came to give evidence, is that this is not something that crosses my desk.
Mm-hmm. Thank you.
Boss.
Lord, I'm just touching on the evidence of Baroness Scotland when she came to give evidence on a previous session. She talked about the Attorney General wearing two hats. One hat was as an advisor to Parliament, and that Parliament can ask for advice of the Attorney General in relation to certain matters. But how do you understand the Attorney General's role in relation to Parliament as regards to the sub judice rule?
Well, it's absolutely right that that part of the Attorney General's ambit can include providing advice to Parliament. As I understand it, that is very rarely exercised. I think Baroness Scotland had an example of it. I'm not sure any of the other three attorneys that you took evidence from had. I haven't. The day job in reality is advising the Prime Minister and the government, and also constitutionally the sovereign. So I haven't had experience of advising Parliament, though of course if there were sort of particular issues about sub judice that I was not already advising the government on and it came through the appropriate route, then of course that's my job to do and I would get on and do it.
So that was a very rare occurrence that would happen.
As I understand it, it certainly hasn't happened since I've been in office. I read with interest what Baroness Scotland said, but it's rare.
Can I just?
Oh, sorry.
Can I just follow up on that? Sorry, sorry, Lord Hermer. You said if you weren't already advising the government, so if Parliament asked first, would you then advise Parliament and not advise the government?
Well, that's a really interesting question, and I'd want to think about that one.
Lee Pitcher.
Thank you. You have kind of touched upon this, and it may be the same answer that you've given previously. But what discussions are there, if any, between yourself and your capacity as Attorney General and the House of Commons authorities, including or specifically including the Speaker?
Yes. Well, again, I have not had to deal with an issue under the sub judice rule.
Okay, thank you.
Mary.
Thanks, Chair. Your written evidence to our inquiry suggests that the Speaker of the House of Commons should publish guidance on what he or she would take into account in granting a waiver. Why do you think that this would be a useful development? And also, can you foresee any risks arising from the publication of such information?
Well, firstly, just to caveat it, it's a respectful suggestion to the Speaker because it's absolutely a matter for the Speaker. I think it would have an advantage of making plain to everybody what the purpose of the general rule, sub judice rule is, and the circumstances in which it might be appropriate to grant a waiver. So there is transparency as to the process. The downsides of having that is if it becomes inflexible, or it is treated almost as a kind of hard and fast rules. So if the Speaker were minded to have guidance, I would respectfully suggest that it would want to stress and have built into it the necessary flexibility and not be seen as a hard and fast rule, but a helpful guide, both to the Speaker, but also to parliamentarians to understand why a waiver is being given, or why a waiver is not being given.
Thank you.
Michael.
Thank you, Chair. Hello. Do you think that all decisions which attract ministerial responsibility, including those of arm's-length bodies or regulators, should be exempt from the sub judice resolution so that they can be discussed in Parliament without parliamentarians falling foul of the resolution?
Yes, as I understand it, there is an exemption for parliamentary for ministerial decisions, so that there because, and that would strike me as constitutionally appropriate, because ministers are answerable to Parliament. And ministers shouldn't be able to hide around court proceedings in order to be able to justify to Parliament decisions that they have taken. In respect of arm's length bodies, I think it depends probably which one. And again, you can pick those by identifying what you consider to be the applicable principle. If it's answerable to Parliament, and they're answerable to Parliament, then there might be a good argument for exemption. If they're not, there might be less compelling reasons. Of course, once those decisions are before the courts of an arm's length body, again, it will depend upon the particular arm's length body, the particular issues that are under consideration, as to whether or not the trial is going to be prejudiced and what lane we are in. So I think it's easier to answer your question firmly in respect of ministerial decisions. It becomes more fact-based when you turn to arm's length bodies.
I might, Chair, just to dig a little deeper on that and separating out the different types of arm's length bodies and regulators. I appreciate that this wouldn't have been done, but how easy or difficult do you think it would be to define the different types of bodies in order to put them into buckets that might be answerable or not if we were to go down this route?
Well, difficult to do off the top of my head now.
Not asking that.
I don't think it should be very difficult. You identify the criteria. Are you answerable directly to Parliament? Are you not? Would just be one. There will be others, I am sure. And then our setup for arm's length bodies will have sufficient clarity in order to be able to properly box each one.
Just in relation to a question earlier from Lee Pitcher about the discussions as Attorney General with House authorities, including maybe the Speaker, about sub judice. I appreciate you answered that question, but I just wondered, were there any circumstances that you could imagine such conversations taking place where yourself as Attorney General would speak to the House authorities about the application?
Well, there may be scenarios in which there's an ongoing, for example, there's an ongoing prosecution and statements are made in the House with the possibility of further statements that the Crown Prosecution Service believe are putting a trial at risk.
Okay.
In those circumstances, the Crown Prosecution Service may come to me and ask me to approach the Speaker. I could foresee that sort of scenario as in theory arising.
Thank you. Lee, Dylan.
Yeah, thank you. So I wanted to talk about the timing of the sub judice resolution. And you've probably seen in some of our previous evidence that it was suggested that it should apply in criminal cases from the point of arrest. So rather than from the point of charge. So the question is, do you think that it would be helpful to the CPS in giving them the space to build a case in difficult or politically charged circumstances?
Yes, I mean, it's one of those areas which, again, I think they're arguments, legitimate arguments on both sides. And the comparison, I think, is with contempt. So the law of contempt, certainly the strict liability rule for contempt, arises from the point at which there has been an arrest, and as you know, privilege, the waiver arises from the point of charge. And it's certainly possible to do a lot of damage to a trial by publicity between the point of arrest and point of charge. And so there are compelling and strong arguments for bringing back the date to the point of arrest. The difficulty, or one of the problems with that, one of the kind of counter-arguments of that, which is a point that the Law Commission addressed when they were looking at contempt, is that since a Supreme Court case of Bloomberg, police don't routinely identify who they have arrested. So it makes it more complicated sometimes if you're liable to contempt in circumstances in which you might, post-arrest, in which you might not know who the individual is. That's in the contempt. And there'll be a mirror, I think, with extending the waiver to Parliament. Again, there's a balance, and I'd be very interested to see where the committee, if this is something the committee looks at, where the committee feels the balance lies. The other tensions is you want to have, there's an advantage in certainty in a rule, which is it starts from point A, everybody knows it's point A, rather than it might be point A or it might be point B. But at the same time, there may be scenarios, if you were to keep the rule at charge and not from arrest, in which people know full well who has been arrested. And to not have that sub judice rule in place with a risk of fair trial, where you know full well, would, I think, offend the underlying purpose and principles as to why you have the sub judice rule in the first place. Having said that, the Speaker retains a discretion, and as I understand it, there has been at least one case in modern times in which the Speaker has effectively introduced the sub judice rule, or at least urged caution upon parliamentarians after arrest but before charge.
And if I can just follow up on that, in terms of either start at A or start at B, but don't allow you to start A and choose B, do you think that comes down to the national profile of the arrest? So, for example, it might be known within my local community who was arrested from word of mouth. You know, a neighbour saw someone being put into a police car, for example, as opposed to it being covered by the Times front page.
Well, it may or may possibly in some cases, but let's say you know the name of the person who has been arrested but is yet to be charged. But it's not out there in the public domain, it's not in the national newspapers. You choose, because the sub judice rule is not yet in force, because there's no charge, you choose to go onto the floor, name that individual, make comments about that individual and that individual's guilt that are then picked up by the local newspapers. The fact that the Times are not running it isn't really going to be an answer to whether that individual has a fair trial or not, nor is it an answer to whether or not you veered into the kind of the court's lanes. So I think the answer is depends.
And then just to push you back on the first question I asked, where you spoke about the different scenarios that could exist and that it's worthwhile the committee looking at it. But can I push you on what would be your preferred view?
As to when it would start? Yeah. My own, I think where I am at, but again, I mean, respectfully, I do want to see where this committee, who's going to have more time and a wider amount of evidence to consider it is. I think where I'm at the moment is it really should be from the point of arrest, or if the identity of the person arrested is known or could reasonably be known. But I really would want to wait for final judgment to.
Yeah, I wasn't trying to trick you.
See where you're at. But that was impressionistic. If you want where impressionistically I would be, it would probably be there.
Thank you.
James.
Lovely, thank you. As you can tell, we've had some interesting discussions on the sub judice and contempt of court. And some of what I was going to touch on, Lee has successfully worked his way through, but I'd like to kind of continue on that kind of interesting thing. Because your written evidence to us suggested that we should consider whether the sub judice rule should be brought into closer alignment with contempt of court. In previous evidence sessions, we've had some discussions as to why they're different, why they work differently. So I just wonder could you expand on your written evidence and kind of what your thinking is around that?
Yes, I mean, look, this is a really interesting area, but I mean, there are some important distinctions. I mean, we just discussed one, arrest versus charge. The tests are lower, as you know, so it's pretty much a complete prohibition under the sub judice rule. For the purposes of contempt, you've got to show substantial harm caused, and that the trial has been seriously impeded. So I mean, it's a different test. You've got no sanction because of Article 9 in Parliament. You've got up to 2 years if you're guilty of contempt. So they're very different. They come from different, although they're all trying to protect the sanctity of the trial, they come from different places. It's one of those areas in which I can see it both ways. I mean, it's ultimately for Parliament to decide where it wants to land, but there's no kind of compelling, clinching argument that they must be the same.
I'll tease you to lean one way or the other, or are you very happy where you are?
I think I'm kind of happy where I am.
He's just committed.
But thank you for the invitation.
Well, you know, I thought it's worth the question.
Gurinder.
Thank you, Chair. So the Speaker in recent times has used his discretion to issue waivers in cases just prior to sentencing, which in cases of heightened public interest. So do you think there is a residual risk of impact in such cases, or is the potential for interference minimal at that stage?
Well, again, I mean, each case will depend upon its facts, I think. And I anticipate one can never say that the impact would be non-existent. Well, there'll be few cases in which you can say it's non-existent. Effectively, what the Speaker carries out is a balancing exercise between, on the one hand, the importance of parliamentarians being able to talk about a case with the risk. And from the waivers that I've reviewed, I would respectfully say the Speaker has got it right.
So, Christopher, I think you wanted to...
Can I just come in on this issue? This is all centred around the need to ensure there's a fair trial. With the propensity of the time between arrest and charge quite often being very extensive now, people may be arrested, but it may never lead to a charge, therefore never lead to a trial. But there can be immense prejudice caused to people who are arrested and never charged and are on police bail, and we know lots of, a number of colleagues anyway in this place and elsewhere who have suffered as a result of that. Do you think there's a role here for the sub judice rule or contempt of court to be extended to cover those cases, which seem to me, because of the increase in police bail, and the length of time between arrest and charge, that it can be a really burdensome injustice for people?
Well, it would certainly be relevant to contempt, because contempt kicks in from the point of arrest. So if the other elements of the crime of contempt were made out, then liability would arise from the point of arrest. I think in respect of the sub judice rule, certainly would be a factor that would go into the consideration as to whether or not to change it to align with contempt, so that the point at which it kicks in is arrest rather than charge. But as I touched on before, there are arguments both in ways. They're kind of competing merits and demerits.
Lord Hermer, I just wondered if you thought that the sub judice resolution should be less strict in relation to appeals, given they're often on a point of law, than it is in a first trial.
Well, again, the answer to that can be analysed through which kind of justification and rationale for the sub judice rule you look at. If you're looking at it from the fair trial alone perspective, then absolutely, because by the time you've got to an appeal, whether it's civil or criminal, you're not dealing with live. You don't have a jury, obviously. You're not dealing with live witnesses who could be intimidated. You're not dealing with people who are not used and trained into ignoring factors that are irrelevant. So, seen simply through the prism is a fair trial possible, then it's far less compelling. The rationale for it is far less compelling at an appellate level. But as I said at the beginning, that's not the only justification for the rule. There's the kind of constitutional comity point. And I don't think that that's necessarily undermined. But I do accept that overall the rationale for it is not quite as strong where the risks of a fair trial are not, I beg your pardon, prejudicing a fair trial are not so real and apparent.
Thank you ever so much, and thank you so much for your very thorough answers today. If there was anything further that you wanted to add, we'd be happy to receive it in writing, but otherwise I think that is in concluding the questions from the committee today. Order.